Hi everyone, and welcome to this week's 6th lecture for AUT's Constitutional Law paper, LAWS607. I hope that you're all doing well in your respective bubbles. I know that this week is a big week for you because for some of you, you'll be finishing off your assignment. I know that some of you have already completed your assignments and have uploaded them, which is fantastic. But this week we are moving from the topic of the legislative arm of government, which we focused on for the previous 2 weeks, to the executive branch of government. And today we'll start with some of the introductory concepts, which include the concept of the Crown. We'll look at the role of the Governor-General, and we'll start to explore prerogative powers. And that will set the stage for next week's lecture, which will focus on the powers of executive government and the forms of accountability and the limits to executive government powers that we have in New Zealand's constitutional system. Now, as always, if you have any questions which come out of today's lecture, you should feel free to get in touch with me. I'll either respond by email, or if you post a question on the discussion forum, then I'll endeavour to respond that way. But I really encourage you, as well as doing the readings, to think about the content of these online lectures and engage with me by asking questions or making comments if you'd like to. Now, you don't need to have a look at my face for this entire lecture, so I'm going to turn the camera off and then I'll continue with the audio commentary on the slides as we proceed through today's content. In this introductory slide, I've just included references to some of the readings which are relevant to this topic on the Crown, the Governor-General and prerogative powers. Bruce Harris, that you're familiar with. I've also included the details of the chapters from Philip Joseph's text, Constitutional and Administrative Law, and there's another book which I mentioned, I think, in the first week, Bridled Power by Sir Geoffrey Palmer and his son Matthew Palmer, now Justice Matthew Palmer, Bridled Power, and that's got a particular chapter 3 which looks at some of the issues that we're talking about today. In the previous 2 lectures, we looked at the legislative branch of New Zealand's government. The key component of that legislative branch, the House of Representatives, is of course elected, and that represents a democratic element in New Zealand's constitutional structure. So we're focusing now on the executive branch, the bits which are circled there on the slide. And we begin with an element that you can't exactly describe as democratic, the monarchy, and one of the terms which is used to refer to the monarchy, the Crown. Professor Joseph describes the Crown in his book as a marvellous emanation of English constitutional history, but he says that it's not always possible to say exactly who or what is the Crown. One of the reasons why the concept of the Crown may be so complex when trying to figure out New Zealand's constitution is that New Zealand's constitutional framework has evolved over many, many years. In fact, New Zealand, as you know, inherited its constitutional framework from Great Britain, and Great Britain had had many hundreds of years of a constitutional tradition before New Zealand came along. Great Britain and New Zealand's constitution have evolved in many ways. They've always, except for a brief flirtation with republicanism under Oliver Cromwell in around 1649, these traditions of Great Britain and New Zealand have always involved a sovereign, a king or a queen. And so it's perhaps not surprising that the constitutional concept of the monarch, sovereign, or the Crown is complicated because it's evolved over many hundreds of years and it's been pushed and pulled in many different directions. 2 of New Zealand's leading constitutional thinkers, Sir Geoffrey Palmer and the former Chief Justice Sian Elias, were asked this question, what is the Crown, in interviews which took place in 2017. And their answers were quite different, but both of them affirm, I think, the complexity of the concept. Have a look at what Sir Geoffrey and Shana Elias said about this.
One of the complexities of New Zealand relates to the expression the Crown. The Crown. Well, the Crown is a very complicated entity. The Crown wears many hats. It's not just the crown on the head of the Queen. It is, in a sense, the government. And how do you distinguish the Crown from the government? Where does one start and the other end?
Well, the Crown is the successor of the British Crown, and the Queen Victoria, was of course a party to the treaty. So the Crown, the executive in New Zealand, if you like, is the inheritor of the obligations that the Queen took on in 1840.
The Crown is also the principal part of the justice system. The judges are Her Majesty's judges. The Queen is the fountainhead of justice. The public service operates in the name of the Crown. And so the Crown is the head of state as well.
When I use the Crown, I'm really talking about the executive government, but that's perhaps a technical use, and maybe people use the Crown to mean the state, because that's also possible. In which case it would embrace all branches of government, legislative, executive and judicial.
So you see, these ideas merge together. They become quite complicated and people don't understand them. It's not surprising.
Okay, so we can see that the Crown is, or this term the Crown, is used for different things in different contexts. On this slide are some examples of different ways in which the term the Crown is used in New Zealand, and you can see there that it's part of the description of Crown law. This is the part of government that advises the executive on various legal issues. We've got the Crown Minerals Act, a piece of legislation that governs extraction of certain minerals from our natural resources. We've got the NIWA, the National Institute of Water and Atmospheric Research, which is described as a Crown Research Institute. There's a section there from the Interpretation Act, or from a piece of legislation, where it notes that the Act binds the Crown. Newspaper reports talking about Crown liability, or commentary on Māori reoffending. We've got the Waitangi Tribunal, which is there to address claims relating to Crown actions. And so there are many different ways in which this term the Crown is used in New Zealand. As a first and maybe rough approximation, we might say that the Crown symbolises both the sovereign and the state of which the sovereign is the head. And so I'm going to spend a few minutes looking at the sovereign aspects of the Crown. So the sovereign, or what's sometimes described as the personal embodiment of the Crown, is at any particular time represented or embodied by a physical person. And that's currently Queen Elizabeth II. But the sovereign, or the sovereign aspect of the Crown, is not only a person, what Philip Joseph describes as the royal personage, but it's also a concept that transcends or goes beyond the existence of Elizabeth Windsor. So, legally speaking, Her Majesty Queen Elizabeth is a corporation soul, and like any other corporation, is not affected by the changing identity of the physical persons associated with that corporation. So companies continue to exist after their founder has passed away. Apple continued after Steve Jobs died, and New Zealand companies will continue after their founders pass away. The physical person of the sovereign will die. Queen Elizabeth II is 94 now. She's reigned for over 64 years. She's beaten Queen Victoria for the English or the UK record, but assuming that the constitutional systems of her realms remain constant, she will be succeeded by these people, which are shown on the screen. We've got Prince Charles, we have Prince William, we have Prince George, we have Princess Charlotte, and then of course Prince Louis has also been added to this, and her successors will die, or perhaps they'll abdicate as King Edward VIII did in 1936, but the crown will continue as if those events didn't happen. There's a famous saying which signifies this idea, that the reigning monarch may die, but the institution of the monarch continues unchanged, and I'm sure that you will have heard of this. The king is dead. Long live the king. Now, this separation between the physical person, the royal personage, and the crown as a corporation soul has a number of important consequences. One of the important ones, significant for us in New Zealand, is though we colloquially speak of the Queen in New Zealand and the Queen in the UK as referring to the same physical person. When we talk of the Queen or Her Majesty or the Sovereign in legal terms, we refer to different entities depending on whether we're talking about her role as the Queen of Great Britain or the Queen of Australia or the Queen of Canada or the Queen of New Zealand. The members of the Commonwealth who retain the Queen as their head of state have agreed to harmonise their laws of succession so that the same physical person is always the king or the queen of each of them. And most recently, those countries, New Zealand, Australia, Canada, and so on, agreed to remove the rules according to which a monarch's son would inherit the throne instead of his older sister. This is known as male primogeniture. And also that a person who is married to a Roman Catholic would be removed from the line of succession. So in New Zealand, those changes were made in the Royal Succession Act 2013, and other members of the Commonwealth passed their own equivalent legislation. Now, the fact that there needed to be separate legislation in New Zealand, in Australia, in Canada, and so on, reflects the separation of the crown, once thought to be one and indivisible, into distinct legal entities for each of the Commonwealth realms. Now, this existence of separate crowns for each of the Commonwealth realms is a symbol of the independence of those realms, but it also has practical consequences. So, for example, we have one person, Queen Elizabeth II, but she is a different legal entity depending on whether she's acting as the Queen of Australia, the Queen of Canada, the Queen of the Solomon Islands, the Queen of Trinidad and Tobago, and of course the Queen of New Zealand. Now, one of the consequences of the separate legal entities is that when acting as the Queen in right of New Zealand, Her Majesty acts on the advice of the government of New Zealand, not the government of the UK. And similarly, when the Queen is acting as the Queen of Australia, she'll act on the advice of the Australian government, not the UK government. Another of the consequences that we'll come back to later on is that, as the Privy Council explained in the New Zealand Māori Council and Attorney General Broadcasting Assets case, the Queen, to whom the Treaty of Waitangi refers, is now Her Majesty in right of New Zealand and not of the UK. So one of the consequences of the separation of the UK and the New Zealand crowns is that the UK crown is treated as a foreign sovereign by New Zealand courts, which means, amongst other things, that the New Zealand government's consent is required before the UK Crown can enforce UK law in New Zealand. And this issue arose in a really interesting case the citation for which is on the screen, the Attorney General of the UK and Wellington Newspapers Limited, which involved an attempt by the UK Crown or the UK government to prevent publication of extracts from this book, Spycatcher, that had been written by Peter Wright, a former senior member of the intelligence or spy community in the UK. He wrote his memoirs, and they included what the UK government regarded as sensitive and confidential information. The UK government attempted to prevent publication of extracts in New Zealand, and one of the issues that came up in that case was whether the UK Crown had an automatic right of audience in New Zealand courts or not. The New Zealand Court of Appeal held that because the UK Crown is different to the New Zealand Crown, that there wasn't an automatic right of audience. However, as Sir Robin Cook said, that it was possible for the New Zealand government to unlock the door to the New Zealand courts for a foreign government by showing appropriate evidence of its support. And as it happened, the New Zealand government did support the UK Crown having a right of audience in the New Zealand courts. It didn't help them a great deal in the end. The New Zealand Court of Appeal held that because most of this material in the Spycatcher book was already public, it had already been published in other countries, that there would have been no utility in an injunction, and the injunction was denied. Let's move now beyond the sovereign as one important sense of the Crown and think about wider meanings of the Crown. So we're moving now from the sovereign as a person in the form of the Queen to broader meanings of the Crown. As a legal entity, the term the Crown is roughly synonymous with the idea of the state. Now, this term, the state, doesn't have a legal tradition in common law countries. Leonard has put it this way, that Her Majesty and Right of New Zealand is, in effect, the legal placeholder for the New Zealand state. And now we've expanded our concept of the Crown from one person to the wider entity of the state. The Crown is not just Queen Elizabeth II and Right of New Zealand, but also, for now, Prime Minister Ardern, the Cabinet, and the various ministries of government. So far, so good, but as I'll mention, outside of these core state entities, Prime Minister Ardern, her ministers and ministries and departments, which we can pretty readily, I think, and intuitively associate with the Crown, it can start to get a little less clear about whether an arm or a leg of the very broad and multifaceted modern public sector is part of the Crown or not. Now, a fair question is, what does it really matter whether a particular arm of the state or of government is regarded as part of the Crown or not? Well, it is important, and it's important for a couple of reasons. First, there are a set of legal privileges and powers which only attach to the Crown, and so there may be important legal consequences of an arm of government or some public function being part of the Crown or not. Secondly, in the New Zealand context, from a treaty perspective, it can become very important to know whether a component of the public sector is Crown or not, because that could make the difference between that party or that public entity having treaty obligations or not. Now, this scope of what falls under the umbrella of the Crown, and so accordingly would benefit from the Crown's privileges and immunities, is not always easy to determine. And over the next couple of slides, I'm going to talk about the ways in which the courts have attempted to apply a test for whether a public entity is part of the Crown or not. Firstly, I should note that it's always open to Parliament, when it creates a public body through legislation, to define in that legislation whether the entity is part of the Crown or part of the executive government of New Zealand. And so that occurred. Here's an example: the New Zealand Railways Corporation Act 1981, where in subsection 1 of section 4 it was provided that there would be this corporation called the New Zealand Railways Corporation, which shall be an instrument of the executive government of New Zealand. So the first point, if you ever have to decide whether an entity is part of the Crown or not, is to have a look at their empowering legislation and see whether it is stated there whether they are part of the Crown or executive government. However, legislation is not always clear, and sometimes it's necessary for the courts to determine whether an entity is or is not part of the Crown. One of the tests which the courts have applied is that of control. So ministers, who, as we'll talk about next week, are appointed directly by Her Majesty through her representative of the Governor-General, are part of the Crown, and departments and ministries and offices over which they preside are all part of the Crown. Departments, including departments listed in the State Sector Act 1988, can also come under the Crown umbrella. But the key point, as we note here from Philip Joseph's commentary, is that to qualify as the Crown, a body must be a functionary of the minister or the minister's department. There will need to be an exercise of ministerial control. And so if a body has a substantial independent discretion, then it's unlikely that that entity will be regarded as part of the Crown or not. And here's a case which illustrated how the courts approached deciding whether an entity was part of the Crown or not. This is the Commissioner of Inland Revenue and the Medical Council of New Zealand, where at issue, amongst other things, was whether the Medical Council was part of the Crown or not. So even though a minister appointed the majority of the Medical Council's members and the minister could remove them for any reason, Justice Keith, for the Court of Appeal, which was unanimous on this point, concluded that the relevant minister did not control the council's exercise of its regulatory functions. And so, for that reason, Justice Keith and the Court of Appeal held that the Medical Council of New Zealand couldn't be regarded as part of executive government. So we have this important legal test of control, and an illustration of that is in the Medical Council case. Let's come back to the sovereign for a moment and think about the practical and the legal implications of arrangements put in place to address the fact that, firstly, the sovereign in right of New Zealand, currently Queen Elizabeth II, most of the time, and now in her elderly years, it's unlikely that we'll ever see her back in New Zealand, is based in the United Kingdom, and she personally is not available to carry out the various functions that the sovereign needs to carry out. So the sovereign, what are some of these functions? They include a number of constitutional functions, and there are also symbolic functions. Queen Elizabeth II can't perform those functions in New Zealand, and so she has appointed a representative. In New Zealand, that's called the Governor-General. And the Governor-General is the Queen's representative in the country, and she performs the various duties that the Queen would perform if the Queen were here. The Governor-General is appointed by the Queen, but on the advice, the binding advice, as we'll talk about next week, of the Prime Minister of New Zealand. And I'm going to talk a little bit about this office of the Governor-General. Legally and constitutionally, it's governed by what are described as letters patent, which constitute the office of the Governor-General in New Zealand. This is an instrument issued by the Queen in respect of New Zealand on the advice of the New Zealand government. And the letters patent designate the Governor-General as the Queen's representative and set out his or her powers, although those powers are always subject to and they can be modified by legislation. The current Governor-General is Dame Patsy Reddy. She was preceded by Sir Jerry Mataparai, a former military officer. Dame Patsy Reddy is a lawyer. She lectured at Victoria University's Faculty of Law before joining the Wellington law firm, which has now become Minter Allison Rudd Watts. She in fact was their first female partner in 1983, specialising in tax and corporate and film law, and she had a number of other senior positions in business before she was appointed as the Governor-General. Very briefly, Section 3, Subsection 1 of the Constitution Act 1986 makes it clear that the Queen and the Governor-General are substitutes for each other. So powers which are given to the Governor-General to be exercised on behalf of the Sovereign may either be exercised by the Sovereign in person or by the Governor-General. So what does the Governor-General do? Well, among their constitutional functions are the tasks of dissolving, proroguing, which is to end a session of Parliament without dissolving it, and summoning Parliament. Also, of course, to assenting to bills, signing off on regulations made by the Governor-General and Council, appointing Prime Ministers, appointing Ministers, appointing Parliamentary Undersecretaries, as well as diplomatic representatives and judges. The Governor-General also, as I'll mention in a minute, is New Zealand's Commander-in-Chief, and he or she exercises the royal prerogative of mercy. Now, these functions are really important, and if the Governor-General exercised them on his or her own, he or she would be a really powerful, although not quite absolute, monarch. However, as we're going to see in more detail next week, the Governor-General actually has almost no discretion whatsoever in the discharge of their constitutional functions. For the most part, he or she acts on the advice of the Prime Minister or the Ministry collectively, and even when not, and even when they exercise what are known as reserve powers, their actions are normally dictated by constitutional conventions. The situations in which the Governor-General will become an actor, a real political actor, have so far remained hypothetical in New Zealand, and most people very much hope that they will always remain so. In 1975 in Australia there was something of a constitutional crisis which occurred when the Labour government, led by Gough Whitlam, had difficulty in passing legislation through the upper house in Australia, the Senate, for what's called appropriation. So this is legislation necessary in order to continue being able to fund normal government activities. There was a deadlock and there were calls by the opposition parties for Gough Whitlam's Labour government to resign, for Gough Whitlam to resign, and for elections to be held. Gough Whitlam didn't believe that this was necessary, and he had other plans for resolving the deadlock. But in the midst of all of this, the Governor-General at the time, Sir John Kerr, dismissed Gough Whitlam as Prime Minister and invited the Leader of the Opposition, Malcolm Fraser, to form a government. That was really unusual because the Governor-General was exercising real political power. It was hugely controversial. And here's a very short video which provides some more of the background of this.
It was a dramatic festival for the media. Speculation was rife that Whitlam and Fraser would still be locked in combat while the country's money actually ran out. Even the banks reluctantly became embroiled.
Yesterday there was an interesting meeting between some Treasury officers and some bank officials, because the government is pleading to the banks to try and get the banks to help the government in evading the Constitution. That's an odd circumstance, isn't it?
There is a principle at stake here which I shall not surrender.
Hardships are inevitable?
Very likely, for many people, undoubtedly.
So if neither...
Many businesses will be badly hurt by the continuing uncertainty which the Liberal and Country Party senators are bringing about.
So if neither side backs down, is chaos then inevitable?
In many respects, it would.
Well, sir, then why don't you give in?
I shan't. It's not just my government. It is the future of parliamentary democracy in Australia as we know it.
So as I mentioned, that event, the dismissal of Gough Whitlam by the Governor-General at the time, was and remains controversial, and the legitimacy of an appointed representative of a hereditary monarch, Governor-General, intervening in political processes and powers that long-standing conventions have removed from the Crown and handed over to governments with democratic basis would be very precarious indeed. And indeed, intervention, if unprovoked, would amount to a fairly significant constitutional crisis. So, in theory at least, an exercise of some of these remnants of the ancient powers of the sovereign might be necessary and were regarded as necessary by the Governor-General at the time. That has never happened in New Zealand, and many people think that it's best if we never found out whether this theory, which would allow the Governor-General some reserve powers in extreme circumstances, is correct. In any event, in addition to their constitutional role, the Governor-General also has a symbolic and a representative one. He or she takes part in the opening of Parliament, and I'll see how that works in a minute. They welcome foreign diplomats and visiting heads of state in New Zealand, and sometimes they undertake visits abroad. They take part in various ceremonies, they meet with New Zealanders, and generally serve as a non-partisan, impartial incarnation of the state. I'd like to move now to the topic of the Crown or Royal Prerogative. Now, the concept of the prerogative can be confusing and has some complexity about it. But broadly put, the royal or crown prerogative is that set of the Crown's inherent powers that exist at any given time. Now, the prerogative was initially very broad. After the Norman conquest in 1066, the English kings were more or less absolute monarchs, constrained, if at all, by the power struggles with their barons, such as that struggle that led to King John signing the Magna Carta, and perhaps by the authority of the Church. But over time, the breadth of the royal or crown prerogative has diminished. So by the 16th century, the British kings or queens had come to share much of their power with Parliament and with the courts. The 17th century saw a protracted conflict over political powers between these institutions, provoked in part by the king's aggressive assertions of their prerogative. Over the course of the 17th century, here depicted by William and Mary, 1689 to 1702, the kings lost most of their powers, partly to the courts and mostly to Parliament. And we get down to the point of time in 2020 where the remnant of inherent crown prerogatives are much smaller than they were previously. Here's a quote or a definition of royal prerogative: the remnant of the once absolute power that has not been taken away by statute or by judicial decision and remains with the Crown. An important case from 1611, this case of proclamations, illustrates an early episode of the 17th century struggle between the king, the courts, and Parliament. The king at the time was James I, and he insisted that he needed to maintain or even expand his prerogative. And he sought approval from the judges for this. In particular, James I wanted to lay down rules by proclamation. He wanted to be able to make laws with the equivalent status of statute, and in doing so would be circumventing Parliament's legislative authority. But the judges at the time refused to grant him the advice that he sought, and on that specific point on which the king had sought advice, the famous Chief Justice Cook took the position which is shown on the slide, that the king by his proclamation or other ways cannot change any part of the common law or statute law or the customs of the realm. The king hath no prerogative but that which the law of the land allows him. So almost at the end of his opinion, Lord Cook slipped in this broader and hugely important principle that the king hath no prerogative but that which the law of the land allows him. And it follows from this statement of principle in the case of proclamations that the courts can review the existence of prerogative powers, and that Parliament has the power of reducing those powers by legislation. Although it's a remnant of once absolute power, the prerogative is now part of and subject to law. Despite having been knocked back by Judge Cook in 1611, during the 17th century in the UK, the kings continued to assert powers, if not to make new laws by proclamation, then at least to suspend existing ones and sometimes to exempt subjects from having to comply with them. The Bill of Rights 1688, which I've talked about a few times in this course already, helped settle this dispute. And in fact, the assertion that the pretended power of suspending laws or the execution of laws by legal authority without consent of Parliament is illegal is that very first article of the Bill of Rights 1688. I think we've mentioned previously, and you've probably come across in your other studies, this important New Zealand case of Fitzgerald Muldoon, in which the then Supreme Court, now the equivalent of the High Court, applied the Bill of Rights 1688 in circumstances where Prime Minister Robert Muldoon had announced that before amending legislation had been passed, employees and employers wouldn't have to make contributions to a pension scheme. A policy decision had been made by Muldoon's government to dismantle this pension scheme, but the law change necessary to implement that policy hadn't yet been passed. The Prime Minister, in advance of the law changing, told people that they didn't need to comply with the law, and when that came before the High Court, Chief Justice Wild said what is noted there on the slide, that he's bound to hold that in doing so, Prime Minister Muldoon was purporting to suspend the law without the consent of Parliament, which was in breach of the Bill of Rights 1688. I might pause here to mention that this issue of the Bill of Rights 1688 has come up again just in the last couple of weeks by these academics, Professor Andrew Geddes and Professor Garinger from Canterbury University, Andrew Geddes from Otago University, in a really interesting online article on the legality of New Zealand's lockdown laws in response to the COVID epidemic. I'm not going to go through this in detail. I think that you might be covering this in the workshops this week, but if you have 10 or 15 minutes, I would really encourage you to read this online article. I've included the quote, the URL at the bottom of that slide. Briefly, Professors Geddes and Garinger have questioned the legality of some of the responses by the New Zealand government in relation to the COVID epidemic, and they have gone so far as to suggest that some of the coercive powers that have been claimed by the government in relation to the pandemic may go so far as to represent a purported suspending of laws without the consent of Parliament, contrary to the Bill of Rights 1688. There have been a couple of important judicial review decisions already testing the legality of government responses to the COVID pandemic. I suspect there will be further cases where these issues will continue to be explored. So just another example, I guess, of these issues which might at first instance appear theoretical, historic. Actually, they're very relevant to assessing the legality of government's actions now. Back to Crown prerogatives now. So I've defined royal prerogative as this remnant of the once absolute power that hasn't been taken away by statute or by judicial decisions and remains with the Crown. Here are some examples of different Crown prerogatives which remain today. So there is the right for the Crown, subject to statute, to be immune from civil or criminal liability, the powers that we've mentioned to summon, prorogue or dissolve Parliament, the power to make prerogative appointments of the Prime Minister, of other ministers, the prerogative of mercy, the reasonably incidental prerogative powers that I'll come back to in a minute, and the important prerogative of conducting foreign policy or continuing foreign affairs relationships, which is a continuing and really important example of ongoing Crown prerogatives. Over the next few slides, I'm going to discuss in a little bit more detail some of the particular Crown prerogatives that I've already mentioned. And firstly, I'd like to talk about the immunity from civil or criminal liability. Now, historically, as an absolute monarch, the King or Queen stood above the law applicable to their subjects. The common law took the position, which is noted here from William Blackstone, that the King can do no wrong, whether civil or criminal, and historically it just wasn't possible to sue the Crown at all. Although it's still the case that the Queen personally can't be prosecuted for a crime, the Crown can now be sued for breach of contract or tort pursuant to the Crown Proceedings Act 1950. And incidentally, this is an example of statute overriding the prerogative recognised by the common law. And statute has also provided other means by which the Crown can be sued. The Crown Organisations Criminal Liability Act 2002 was passed to remove the Crown's exemption from prosecution for offences under the Building Act 1991 and the Health and Safety and Employment Act 1992. That was one of the key recommendations of Judge Noble in his report into the Cave Creek tragedy. It's possible to seek damages against the Crown in rare circumstances under the New Zealand Bill of Rights Act, and we may discuss that later in the course. Another prerogative is the Crown's original position as being above, or another example of the Crown's position as being above the law is the so-called immunity from statute. Although this immunity, of course, can be overridden by legislation. That's now reflected in Section 27 of the Interpretation Act, which codifies the common law rule in this regard and perhaps goes even a little further, providing that no enactment binds the Crown unless the enactment expressly provides that the Crown is bound. However, the courts have interpreted this requirement of an express statute, that a statute binds the Crown, as including cases where the statute's applicability to the Crown is a necessary implication. Otherwise, many statutes obviously intended to bind the Crown, such as the Constitution Act, for example, would fail to do so. And if you're interested in that, you can read a little more about it in Philip Joseph's text. What about summoning, proroguing and dissolving Parliament? Well, as we've seen in the case of proclamations, the Crown cannot legislate by prerogative. However, the royal assent, which is a necessary step of the legislative process, is a prerogative act. And it's also a prerogative act to summon, to prorogue, or to dissolve Parliament. We have legislation, including the Bill of Rights 1688, which provides that parliaments ought to be held frequently. But we have a situation where the sovereign, through the Governor-General in New Zealand, takes these steps of summoning and proroguing and dissolving Parliament, following ancient traditions. And I've got a short video here which depicts the process of opening Parliament in New Zealand, including as part of this ritual the entity called Black Rod, who is explained in the video, who approaches the door to the chamber of the House of Commons, the House of Representatives in New Zealand, to make their summons, and as they do so, the door is symbolically slammed in their face. This is to symbolise the Commons' independence of the sovereign, and then Black Rod strikes the door 3 times with his staff and is then admitted and issues the summons of the monarch to attend Parliament. Let's have a look at this.
They're greeted here by Black Rod, as I say, Governor-General's representative. Mr. David Baggerley, the Director of the Honours Secretariat, is Black Rod at the moment. And followed by the Kaikaranga of the Tangata Whenua, the person who will call out the karanga to announce the arrival of the justices. They head to the top of the steps in Parliament. Yapera Moeahu from Wellington and now Taranaki is the Kaikaranga. Sheriff Gill leading the judges up. The reason why the judges are sent is, of course, that by ancient tradition the monarch or the monarch's representative may never enter the chamber of the House of Representatives, just so that we all know there is no interference in the work that is carried out by our Parliament by the monarch. So he sends judges to set the wheels in motion, as it were, on his behalf. Making their way now through the foyer of the House. Black Rod leads them through. They go past the statue of Saraparani Ngata into the Grand Hall, making their way to the debating chamber. Greeted here by Kahurangi, the very well-known internationally performing group, come from the Hawke's Bay, and it's their honour today to sing the Waiata, which welcomes him.
Okay, the next prerogative that I want to mention is the prerogative to appoint and confirm ministers of the Crown, and there are multiple prerogatives here relating to the exercise of executive power, including the appointment of ministers who formerly hold positions of the Executive Council, a descendant of the King's Privy Council, diplomats, civil servants and judges. Their appointments are all exercises of the prerogative power. At common law, these sorts of appointments used to be at the King's pleasure, meaning that the King or the Queen could dismiss that person that they had appointed at will. However, statute has changed the position and the security of tenure for many of these appointees. Judges may have been appointed during good behaviour, which means that they can't be dismissed without cause since the Act of Settlement 1701. And now we have legislation which governs the conduct of judges that we will have a look at a little bit later in the course. External affairs are another aspect of executive power in which Crown prerogative plays an important role. So the Crown signs treaties, it sends and receives ambassadors, it declares war, it makes peace, it recognises foreign states in the exercise of its prerogative. The Crown's command of the armed forces was also originally purely a matter of prerogative. However, here too the Bill of Rights 1688 made an important change by prohibiting the raising or keeping of a standing army within the kingdom in times of peace unless it be with the consent of Parliament. So in New Zealand, the Defence Act 1990 supplies Parliament's consent for the raising and maintaining of an army. I'd like to talk briefly about the prerogative of mercy. The King's historical status as the fountain of justice and the holder and source of judicial power continues in this prerogative of mercy. And this is the power which can be exercised by the Governor-General on advice of the Prime Minister and Cabinet to pardon convicted criminals. The Crown is able to mitigate or even annul the verdict of the courts by pardoning people who have been convicted of offences. And this prerogative power is particularly important to rectify miscarriages of justice. And on the slide there are some notable examples of the exercise of prerogatives of mercy through pardons in New Zealand. Te Kuti pardoned in 1883. Arthur Allen Thomas, who had been convicted of murder, was pardoned in 1979. I've also shown there Scott Watson, who has been convicted of murder, who requested a pardon which was rejected in 2013. That's also governed in Section 406 of the Crimes Act 1961. Now I'd like to finish with a final question to consider, and that is, what is the scope of the Crown's freedom of action in situations that don't fall within one of the recognised prerogative powers, but where there is no rule of law, whether that is statute or common law, that explicitly prevents the Crown from acting? This is sometimes described as the residual freedom or the issue of reasonably incidental powers. There's a long discussion in Philip Joseph's text on this, but it was an issue that came up in the case in England of Malone and the Metropolitan Police Commissioner, a case which concerned the legality of police tapping phones of citizens in circumstances where there wasn't an explicit power for the police to be intercepting these sorts of communications, but neither was there any obvious law against it. And in that case, the Chancery Division of the English High Court of Justice held that it was lawful for the Crown, as for any other person, to do anything that was not prohibited by the law. And you can see the quote there from Sir Robert McGarry. Now that case has been quite controversial, and as I mentioned, there is a long discussion on it in Philip's Joseph text. The concern, amongst others, is that this complete freedom gives the Crown too much power, and the concern is that public power could be used arbitrarily or to any purpose, including bad or malevolent purposes, so long as it wasn't contrary to existing law. Philip Joseph's preference is not to rely on this type of power or this legal position that the Crown can do anything which is not prohibited by law, by preferring an approach which would allow the Crown to act in circumstances where either there has been an explicit prerogative or statutory power to act, or if the need to act is reasonably incidental to explicit prerogative or statute powers. And although this area of law is in flux, that's something that you can explore further in Philip Joseph's text. Let's summarize where we've got to now in terms of the entire lecture. My first point was that this concept of the Crown is an important one in New Zealand's constitutional system. However, exactly what we mean by the Crown, where it begins and where it ends, is not a carefully worked legal creation. I noted that the phrase "the Crown" is used in different ways in different contexts, and it's important to be aware of the flexibility and also the complexity of the concept. One of the meanings of the Crown is the sovereign, who is both represented or embodied by a physical person, currently Queen Elizabeth II, but it's also a concept that transcends or goes beyond the existence of that physical person. Legally, the sovereign is what I've described as a corporation's soul, which, like any other corporation, isn't affected by the changing identity of the physical persons associated with that corporation, and that's reflected in the phrase "the king is dead, long live the king." I talked about when we speak of the Queen or the sovereign in legal terms, we refer to different entities depending on the Commonwealth country at issue. For New Zealand, the Queen is Her Majesty in Right of New Zealand, and that is a different legal entity to Her Majesty in Right of Australia or the UK and so on. And that principle was illustrated in the Spycatcher case that we talked about. Correctly identifying what parts of the very broad and complex modern state are the Crown or the executive government of New Zealand is not always a simple task. Sometimes, such as in the Railways Corporation legislation that we talked about, the statute will define whether an entity is to be treated as the Crown or not. In other cases, the courts will apply this control test, examining the nature and degree of control the Crown exercises over an entity, and that was illustrated in the Medical Council of New Zealand case. The Queen's representative in New Zealand is the Governor-General. The Governor-General, currently Dame Patsy Reddy, performs these various duties that the Queen would perform if she were here, and that's covered in the Constitution Act 1986. We spent some time talking about royal or Crown prerogative, which is the remnant of that once absolute power that hasn't been taken away by statute or by judicial decision and remains with the Crown. And I explained how the extent of royal prerogative has steadily diminished over the course of English, United Kingdom, New Zealand constitutional history, as powers formerly held by the sovereign have been lost, partly to the courts, but mostly to Parliament. We talked about some of the important Crown prerogative powers which continue today: immunity from civil or criminal liability, immunity from statute, the power to summon, prorogue, dissolve Parliament, the power to make prerogative appointments, the external affairs prerogative and the prerogative of mercy, and that final category not completely settled now of reasonably incidental prerogative powers. On their face, these various statutory and prerogative powers, which are enjoyed by the Governor-General on behalf of the Sovereign in New Zealand, are very broad. In practice, however, the Governor-General has almost no discretion in the discharge of his or her constitutional functions. We haven't had situations in New Zealand like happened in Australia in 1975, when the Governor-General has exercised real powers. So for the most part, they act on the advice of the Prime Minister or the Ministry collectively, and even when exercising these reserve powers, their actions are normally dictated by constitutional conventions. The important role of the government in relation to those executive powers will be explored next week. So it just remains for me to give you the heads up for next week, where we will be looking at the powers, limits and accountability of executive government. There are some references there to Bruce Harris's text, the case of proclamations, which I've mentioned briefly today, Fitzgerald and Muldoon, and the State Services Commission Political Neutrality Guidance. Have a good week. For those of you still working on your assignments, I hope that that goes well, and I'll look forward to engaging with you again next week in constitutional law.